regulations than their large competitors, if we are relying on small businesses to create jobs that will create economic growth, America's entrepreneurs cannot be saddled with unnecessary costs. It is just plain common sense that federal agencies should see how the rules will affect businesses, businesses that need scarce capital to hire workers rather than comply with costly and unwieldy dictates of federal bureaucrats. In fact, such a statute exists, the Regulatory Flexibility Act, or RFA. The Act charges all federal agencies with examining the impact of their proposed and final rules on small businesses. If these impacts are significant, the agency is required to consider less burdensome alternatives. Let me give an example. TSA decided that it would be a good idea to impose on general aviation security plans and screenings similar to that used by commercial airlines. Significant cost would have been imposed on the general aviation community without any showing that safety to the public would have increased. It is this type of nonsensical federal overreaching that hinders job creation without providing any benefit to the public that the RFA was designed to stop. Had TSA done what was required under the Act, that agency would not have put forward such a proposal. Despite the importance of the RFA to the small business community, federal agencies, as we will hear from today's witnesses, regularly ignore the requirements of that Act. The result is reduced competitive capability of small businesses, which in turn prevents them from expanding and creating needed jobs. Given the state of the American economy, that is not a result we in Congress or the American public can afford. I want to thank witnesses for taking the time to provide their insights into the RFA, its benefits to small businesses, and the loopholes that agencies may use to avoid a necessary and sensible examination of the consequences of their actions. With that, I now recognize the ranking member for her opening statement.
Thank you, Mr. Chairman. Good afternoon. Small businesses play a key role in creating new jobs. Today, we're going to examine how the rising regulatory burden may prevent them from generating these employment gains. As the latest studies show, the annual cost of regulation grew over the last decade to $1.75 trillion. This means that if every U.S. household paid an equal share of the regulatory burden, each will owe more than $15,000. For many small businesses, the cost of regulatory compliance has become considerable. Firms with fewer than 20 employees pay more than $10,500 per employee in compliance costs, a number 36% higher than the larger counterparts. The result is that many entrepreneurs are spending more on regulatory requirements than they are on building their businesses. To address this issue, Congress passed the Regulatory Flexibility Act in 1980, giving small businesses greater influence in the regulatory process. The Act was designed to ensure that federal agencies consider the impact of its regulations on small entities. Clearly, the RFA is working as regulatory costs were reduced by $15 billion in 2010 alone, according to the SBA's Office of Advocacy. In the last 3 years, the EPA and OSHA convened 7 small business advocacy review panels, providing small firms with greater input regarding key environmental and occupational safety regulations. Despite these successes, it is clear that RFA could be working better. One area that needs improvement is the process in which agencies can certify that a rule has no significant impact on small businesses. While agencies are required to provide a factual basis for such certifications, they often provide only a simple statement which dismisses the concerns of small firms. By doing so, small firms are often left out of the process, with little hope of their voice being heard. Agencies also have been slow to review outdated regulations that remain on the books, yet which continue costing small businesses money. While the RFA requires agencies to periodically review existing rules, these requirements are vague, and agencies often do not apply them consistently. As a result, these reviews have been much less effective than they could be. Given the well-documented concerns and the evidence that lies before us, I think the question is not if we make improvements to the RFA, but rather how do we go about it. As we move down this path, the committee should be cautious in two areas. While the SBA's Office of Advocacy plays an important role, simply giving them additional power is not the answer to all that ails the RFA. With only 46 employees, we have to be careful about creating a situation where we vest too much new authority in an entity that lacks the budget and manpower to execute such an expanded role. In these times of fiscal restraint, I am very worried of heaping more responsibilities on an agency that is struggling to keep up with existing workload. Let's first see if advocacy can handle the new tasks required under Dodd-Frank, which increases by 50% the number of agencies covered by the panel process. In addition, any expansion of the RFA, and in particular, the panel process, must be scrutinized. I wholeheartedly support efforts to rein in agencies that are insensitive to small businesses, but we cannot do so by simply grinding the regulatory process to a halt. With this in mind, I look forward to today's discussion on how RFA can be best modernized to meet small businesses' needs. And let me take this opportunity to also thank all the witnesses for being here today. Since its enactment over 30 years ago, the Regulatory Flexibility Act has played a critical role in reducing regulatory burden. We need to ensure our RFA system functions properly and correctly, as minimizing regulation will enable small businesses to do what they do best: innovate, grow, and create the jobs our economy needs to move ahead. With that, I yield back the balance of my time.
I thank the ranking member, Congresswoman Velasquez. All the witnesses' written statements will be placed in their entirety into the record of the hearing. The first witness will be Mr. Squires. Mr. Bill Squires is the Senior Vice President and General Counsel of Blackfoot Telecommunications Group in Missoula, Montana, and is testifying on behalf of the National Telephone Cooperative Association. Mr. Squires, you will have 5 minutes to present your oral testimony.
Thank you, and thank you for the invitation to participate in today's discussion on controlling the reaches of federal agencies and considering modifications to the RFA. For the past 10 years, I have served as Senior Vice President and General Counsel of Blackfoot Telecommunications Group in Missoula, Montana. Blackfoot is organized as a cooperative, and as such, our priority is to provide to our customers, who are also our owners, the very best communications and customer services available. We serve only 21,000 customers in western Montana over an expanse of about 6,500 square miles, so only a little over 3 customers per square mile. We have approximately 140 employees, and in 2010 had operating revenues of $34 million. So we are a small, highly regulated company. The entrepreneurial spirit of Blackfoot is represented by approximately 1,100 small rural counterparts in the telecom industry, who together serve 50% of this nation's land mass, but only 10% of the population. Rural providers are early adopters of new technologies and services. Blackfoot currently offers 15 megabit broadband service to 98% of that 6,500 square mile service area. Territory. Thanks to rural telecom providers, rural Americans are enjoying universal voice services, access to broadband internet, and enhanced emergency preparedness. To counteract the natural inclination to develop a one-size-fits-all approach to regulation. The RFA was adopted in 1980. It directs agencies to balance the societal needs tied to federal regulations with the needs of small businesses. Though the RFA has been good for small businesses, many industry stakeholders believe that some agencies, and in our industry particularly the FCC, gives little regard to the law and its mandate to thoroughly review the impact of proposed regulatory orders on America's small business community. The RFA is supposed to force agencies to be creative with regulatory alternatives. Instead of conducting this analysis, agencies often summarily state that alternative regulation was considered and rejected. Among the FCC's rules, for example, that have a significant and unnecessarily damaging financial impact on small carriers are things such as truth in billing, bill shock, slamming, customer proprietary network information rules. These are all laudable goals, and I don't question those today. However, in the instances where final rules have been adopted, the Commission did not fully analyze the impact of its rules on small businesses and did not fully explain why alternatives were rejected. In response to the FCC's continued disregard of the RFA, the National Telecommunications Cooperative Association actually sued that agency in 2004 over its new number portability rules, which were heavily skewed in favor of very large companies. The court forced the FCC to perform the required RFA analysis, and NTCA members offered suggestions on lessening the burdens that the rules would have on small businesses. The FCC rejected and ignored the suggestions of NTCA, and NTCA sued again, arguing that the analysis was deficient. Amazingly, the court stated that the RFA's requirements are purely procedural. It requires the agency to do no more than state and summarize issues. I simply can't believe that it was Congress's intent in passing the RFA. Because the FCC is an independent agency, it's largely not subjected to direct oversight by the OMB's Office of Information and Regulatory Affairs. The OIRA was created by Congress to review federal regulations and reduce burdens. Further, FCC is not required to comply with Executive Order 13272, which specifically deals with cooperation with the Small Business Administration's Office of Advocacy, nor is it subject to Executive Order 12866, which requires a cost-benefit analysis for all significant rules. We believe the following legislative actions could go a long way toward enhancing small business participation in the dynamic communications sector. Codify the appropriate provisions of the executive orders in a manner to make them applicable to independent agencies such as the FCC. Require all agencies to explain whether and how each rulemaking decision promotes and protects small businesses. Amend the RFA to clarify that all agencies must suggest and analyze creative alternatives that account for the nature and competitive position of small businesses when conducting rulemakings. Certainly consult with the Small Business Administration's Office of Advocacy well in advance of rules being adopted and specifically address any suggested authority. Provide the FCC with the responsibility to require agency bureaus to coordinate regulatory activities. Members of the committee, we're excited to have your attention today, and I appreciate the opportunity to be here. We're excited to have your leadership to develop policies that will give America's small businesses the confidence to invest and flourish. Thank you for the opportunity to be here today, and I look forward to answering any questions you may have.
Mr. Squires, thank you so much for your testimony. Ranking Member Congresswoman Velasquez, I believe you have a, oh, I'm sorry. Mr. David Frula, if I pronounce that properly?
Yes, you are. Thank you.
Okay. Is a partner in the Washington, D.C. office of Kelly Dreyer. Mr. Frula, you have 5 minutes to present your testimony.
Thank you very much, Mr. Kaufman, Ranking Member Velasquez, and members of the committee. I am David Frula from Kelly Dreyer in Washington, D.C. I appear today personally, though I've long helped small businesses try to cope with federal rulemaking, including in over about a dozen RFA-related court cases, several times successfully. It is important testimony here today regarding the Regulatory Flexibility Act as Congress seeks to ensure federal regulations do not impede economic recovery and job creation. In summary, the RFA, along with its watchdog, the SBA's Office of Advocacy, have proven valuable in leveling the regulatory playing field for small businesses, nonprofit organizations, and governmental entities over the last 30 years. In short, the office does a great job in its role as a liaison for small entities to the Federal Government, and it deserves the resources it needs to fulfill its mission, especially if that mission is going to be enhanced. More does need to be done, though, to ensure Federal regulations match the scope and scale of these small entities. As I will explain, certain RFA weaknesses have emerged since the Small Business Regulatory Enforcement and Fairness Act, or SBREFA, provided for judicial review of agency RFA analyses in 1996. The heart of RFA analyses are agencies' preparation and publication for notice and comment of an initial regulatory flexibility analysis, and then the preparation of a final regulatory flexibility analysis at the time of final rules published. Most importantly, these analyses should explore significant alternatives that reduce adverse impacts on small businesses, and the FERFA should explain why it rejects less flexible alternatives. In general, an agency can only avoid the RFA if it certifies the rule is not likely to have a significant impact on a substantial number of small entities. These Section 605B certifications have proved to be controversial. Importantly, courts have interpreted the RFA to be strictly procedural, and that limits its utility. A very deferential Administrative Procedure Act standard of review applies. It's an open question how much deference the expert SBA Office of Advocacy is entitled to when it disagrees, as it sometimes does, with agencies' analyses. And agencies have often been able to create their own ad hoc RFA standards that are contrary to SBA guidance and inform public input. Perhaps most significantly, an agency is not required to adopt any more flexible regulatory alternative, and courts generally defer. Whatever the cause, that outcome is not acceptable. Further, there's an ever-growing line of cases that find an agency need not comply with the RFA if the rule does not directly impact a universe of small entities. The origins of this construction are both sketchy and non-statutory. Also, there have been difficulties with Section 610 regulatory review. An extensive empirical analysis has shown that these large-scale regulatory reviews have not succeeded and may even have been counterproductive. This is particularly discouraging given the current legislative focus on retrospective reg review. SBA also included the panel requirement that the ranking member discussed. These panels have helped avoid ready, fire, aim regulatory outcomes. Fortunately, there are good ideas in play to amend the RFA, and I actually have one or two more of my own that I'm going to bring forward. It is important to give the Chief Counsel of the Office of Advocacy the authority to draft uniform implementing regulations for agencies to follow. For instance, EPA should not be able to, as it illogically does, assess the impact of a rule based on its impact on small business revenue without considering the profits needed to fund the change. H.R. 527 would provide for this more formal SBA rule. Small entity outreach should be expanded during the pre-proposed rule stage, along with increased use of SBREFA-type panels. President Obama himself has emphasized such proactive outreach. Include indirect effects. When, for instance, states merely act as regulatory intermediaries, there's no reason an agency can't assess the rule's impact on the small businesses that will ultimately have to comply. H.R. 527's foreseeability concept is on target. Regulatory review. Your proposed bill also enhances the 610 reg review process, and that should be strengthened, consistent with other legislative efforts to enhance retrospective reg review being considered in this Congress. The bill also understands the need for better understanding and minimization of cumulative regulatory impacts. You need to add teeth to the regulatory alternatives development process. Courts and agencies have both lost sight of the admonition in the RFA's legislative history that the law should be liberally construed to fulfill its purposes. It's not an easy legislative issue. If you'd permit just one more minute so I can finish up. Thank you. But here's what Congress can do. It can mandate the use of the best scientific, economic, and social information available in these analyses and let the SBA define what those terms mean. And it can provide for peer review in appropriate instances. Congress should consider developing a process where small entities could petition the Office of Advocacy to convene a peer review of an agency's RFA analyses, especially as they relate to alternatives. It shouldn't be automatic, but let the SBA take a look at that and decide where it's appropriate. And then these peer review results could be accorded judicial deference equal to the agency's own RFA analysis. Then you get a better playing field at the courts. And finally, opportunities for judicial review should be enhanced so they're effective. On the substantive matter, we just talked about the issue of deference, but also small business should not have to wait, as one of our clients did, 4 years for a court to conclude that the agency should have conducted an RFA analysis in the first place. Congress also needs to consider the heavy costs of federal litigation on small business. Thank you very much. I look forward to answering any questions you may have.
Thank you, Mr. Frula. Thank you, Mr. Frula. The Chair recognizes Ranking Member Congresswoman Velasquez.
Thank you, Mr. Chairman, and it's my pleasure to introduce Craig Fabian. He's the Vice President of Regulatory Affairs and Assistant General Counsel for the Aeronautical Repair Station Association. He's also a practicing aviation attorney and has over 20 years of experience in the aviation industry. He began his career as an aircraft mechanic technician with Northwest Airlines, worked as a maintenance controller for U.S. Airways, and is the former director of technical operation for the Air Transport Association. Welcome.
Thank you, Ranking Member Velasquez and members of the committee. Thank you for the invitation to testify this afternoon. For those of you not familiar with the Aeronautical Repair Association, known as ARSA, it's the premier association for the international aviation maintenance industry. ARSA certificated repair station members facilitate the safe operation of aircraft worldwide. From an economic perspective, the aviation maintenance industry generates over $39.1 billion of economic activity in the United States and employs more than 274,000 workers in all 50 states. A snapshot of our economic and employment footprint is attached to my written testimony. On a global scale, North America is a net exporter of aviation maintenance services, enjoying a $2.4 billion positive balance of trade. Although ARSA members represent a wide cross-section of the aviation industry, the vast majority of these companies are small businesses. As a result, the protections afforded by the Regulatory Flexibility Act, which I will refer to as the RFA, are particularly meaningful to our members. Today, I will discuss ARSA's experience in challenging an agency rule under the RFA. That experience began with a decision by the Federal Aviation Administration, or FAA, to dramatically expand the scope of its drug and alcohol testing requirements. The changed rule impacted many traditional small businesses that certificated repair stations rely on for ancillary services, such as welding shops, metal finishers, and machine shops. Those small businesses were faced with a difficult choice: either implement a full-blown FAA drug and alcohol testing program or simply stop serving repair station customers. ARSA challenged the rule in court, and in 2007, the U.S. Court of Appeals for the D.C. Circuit found that the FAA had violated the RFA when it decided that a full analysis was unnecessary. The FAA was then instructed to perform an analysis to comply with the RFA. Despite the court's mandate, over 3 years passed and the FAA made no effort to perform the required analysis. As a result, on February 17th of this year, ARSA filed a petition for writ of mandamus with the same court to compel the FAA's compliance. Several weeks later, the FAA was ordered to show cause and explain why ARSA's petition should not be granted. As a basis for its response to the court, the FAA posted what it characterized as a supplemental regulatory flexibility determination, restating its conclusion that a full and complete RFA analysis is not required. To put it briefly, despite the passage of time, over 5 years since the final rule became effective and over 3 years since the court's mandate, the issue is far from over. ARSA's experience in dealing with federal agencies reveals that the RFA is treated as an annoying burden to the rulemaking process. The agency's objective seems to be finding a way to avoid engaging in the difficult task of compiling the economic data and considering alternatives to a proposed rule. Indeed, even when specifically commanded by a court of law to carry out an analysis, federal agencies are prone to engage in foot-dragging with the apparent hope that the requirement will just go away. We believe the following suggestions will help. Congress should allow small businesses and nonprofit associations that successfully mount RFA challenges to recover court costs and legal fees. The RFA could be amended to require that agencies assess direct and indirect costs for small businesses. The RFA could be amended to prevent agencies from reversing determinations made during its threshold analysis as to what entities are affected by a proposed rule. Congress could ensure that any legislation it passes contains language, either in the bill itself or in legislative history, clearly stating that it does not intend the law to have adverse effects on small businesses. Congress could empower the Small Business Administration's Office of Advocacy to make small business determinations for agencies. Congress could also refrain from setting strict timelines that agencies must meet to complete the rulemaking process. Small businesses are a critical part of the aviation industry and the U.S. economy. When it enacted the RFA, Congress created an important mechanism to protect small businesses from unnecessarily restrictive and intrusive federal regulations. However, the small businesses in your districts will only benefit from the protections of the RFA if federal agencies obey the law. Thank you for your time, for holding this hearing, and for inviting ARSA to be part of it. I'd be happy to answer any questions.
Thank you for your testimony. And now for the most important part, the dessert portion of the hearing. I would like to welcome Mr. Rich Draper, CEO of the Ice Cream Club, Boynton Beach, Florida, testifying on behalf of the International Dairy Foods Association. Mr. Draper, you will have 5 minutes to present your oral testimony. Please speak into the microphone, make sure it's on. Thank you.
Ranking Member Velasquez, members of the committee, and especially my Congressman Alan West from Florida's 22nd District, who is so committed to small business. Sorry I didn't bring any samples today, and if I'm invited back, I will. I also want to recognize the International Dairy Foods Association, the leading voice of the dairy industry, for their help with today's hearing. And I would be remiss if I didn't mention my wife and business partner, Heather, who is with me today. Just briefly, Heather and I have been married recently, 2.5 years ago, first marriage for both of us. She's a former executive in the banking industry. So I feel I've done my part to move the economy forward by adding her tremendous talents to the manufacturing industry and also removing one from the banking industry. All right. A brief description of my company, the Ice Cream Club. In 1982, a buddy of mine, Tom Jackson, and myself opened up an ice cream shop in a little town called Manalapan in South Florida near Palm Beach. Those were the good old days when you could just come across an opportunity and pack up and go. We started making ice cream in the back of the store and shortly thereafter began wholesaling. Today we produce over 120 award-winning flavors and are known for our crazy mouth-watering varieties, but we only produce in 3-gallon tubs, so we're not available in grocery stores. We supply 500 food service accounts throughout the Southeast and Caribbean. About 7% of our business is export, and that percentage is growing. We now employ over 50 people and operate from an 18,000 square foot factory, and we continue to grow. In fact, this year we've hired 7 new staff members. We still have our original store, and my partner Tom is still with the company. We deal with regulations and local, state, and federal levels by multiple agencies who are very interested in today's hearing topic. We fully support the efforts of this committee to ensure that federal agencies make regulations as efficient and as least burdensome as possible for small business. Let me touch briefly on some items of concern for the Ice Cream Club. There's nothing more important to the success of our business than the confidence our customers have in the safety and quality of our products. We welcome government regulation and inspection when it is utilized as a partnership between industry and government to further enhance the safety of food production. However, we are worried about duplicative regulatory agencies at various levels of government. For example, we are inspected regularly by the Florida Department of Agriculture, part of the USDA. Also, we are inspected by the FDA. We have 4 major inspections by the Florida Department of Agriculture each year, as well as numerous other visits to collect samples and calibrate equipment. The new food safety law passed by Congress last year calls for even more inspections for food manufacturers, so it will be particularly important that the FDA utilize existing inspections in the dairy industry as much as possible. We are concerned that instead of targeting increased inspection to high-risk areas, FDA will take a one-size-fits-all approach over the entire food sector. We hope that there is not an adversarial gotcha approach coming down the pike. Our view is that the vast majority of food producers adhere to strict food safety procedures and are working very hard to provide safe, quality, consistent products to the public. Recently, the FDA began targeting certain segments of the dairy industry for extra environmental testing. FDA's process can take anywhere from a few days to more than a month to get test results back. During that time, businesses have to hold product in inventory, and production lines may have to be slowed down until FDA results confirm that products are safe to be shipped. These additional inspections are slow, and response by the FDA make the cost of doing business higher for small business, and the FDA should be required to determine if these extra costs can be avoided. Another example of one size does not fit all is when we try to sell to the government. For example, if we wanted to sell to a VA hospital, we have several roadblocks potentially in our way. One is the size of the bid. They may require all fluid, including ice cream and milk. We only do ice cream. It could be a geographical boundary, say the entire eastern United States. We only supply the southeast. That also goes against the buy local movement, which has benefits. Plus, we'd be subjected to additional USDA inspections. We make over 20 flavors of no sugar added ice cream. I'm not aware of any other company that does. I think that'd be a great addition to a VA hospital. We just like the opportunity to be able to go in and say, we're meeting all other regulations, let us have a shot. Since milk is the primary, I'm going to move ahead in just a second here. Finally, I would like to suggest more involvement by small business at the inception of regulations. This could be accomplished by a small committee of business people such as myself that could offer input not as a way to get a competitive advantage or take shortcuts, just smart input from people on the front line. In conclusion, I want to say that I feel very fortunate that we're operating in a country that allows us to grow our business. Much of the world's population is under an oppressive regime of some sort, so we can't complain too much, so we will take reasonable regulations over the alternative. Thank you very much.
Thank you, Mr. Draper. I think what we're going to go ahead and break now to vote, and then I appreciate your testimony, and then we'll return for questioning.
And that's what we were talking about the other day.
We'll go ahead and call the hearing back to order. I apologize to everyone for missing the first part of it. I had a speaking engagement I had to be at, and then, of course, we had votes. But with that, we're ready to start questions. And I appreciate, again, all of you being here, and I know some of you traveled a ways, and we always appreciate that here at the committee. But my specific question for you all when it pertains to the Regulatory Flexibility Act, on January 19th, the President reaffirmed the need for federal agencies to comply with the act. And my question to you is, have you seen any improvement in agency assessment when it comes to small businesses and as it pertains to the Regulatory Flexibility Act? And I would also be interested in any specific things that's happened in the last year that frustrate you for the administration when it comes to the Regulatory Flexibility Act, specific items that have happened to you. And we'll start with Mr. Squires.
Thank you, Mr. Chairman. To answer the first question, the agency, of course, that we deal primarily with is the Federal Communications Commission, the FCC. And as an independent agency, they are exempt from some of the executive orders that control federal agency responses. And so we have not seen since January great improvement in at least the FCC's compliance with the RFA. And as an example, and this addresses, I believe, your second question for frustration, at least on my part, is a recent notice of proposed rulemaking currently pending in the FCC, which is sweeping regulatory change to our industry, pays very scant attention to the initial regulatory flexibility analysis that's required under the RFA. There's just a few paragraphs in, I believe, Appendix H of that notice of proposed rulemaking that essentially asks all of us, the small businesses, well, you tell us what maybe are some ideas to reduce the burden of regulation on you. And it's my belief that the RFA really places the burden, and rightfully places the burden, on the agency itself to come up with those creative alternatives, not simply punt in a few paragraphs of a 300-page order the burden to small businesses such as ours to come up with those alternatives.
Thank you, Mr. Chairman. I have seen some slowdown of agency rules, maybe for a little bit more deliberation. The EPA has done some of that. It hasn't seemed to me to be small business focused. It's been more on the general policy rather than on the presidential memorandum relating to RegFlex and small business. In terms of what's been, I think, maddening for everybody on the panel is an easy way now for an agency to handle the Regulatory Flexibility Act is to say, okay, and we run into this fairly constantly. Yeah, we get it. You're going to get creamed. But we have to. We don't have any alternative. And that's the sophisticated approach. It sort of evolved from there's no impact to you're going to get creamed. We can't do anything about it, and they go to court, and the court defers to the agency's rather superficial analysis.
Thank you, Mr. Chairman. I would point out a very recent example this month, as a matter of fact, and mentioned in my written and oral testimony. The FAA's recent posting of a regulatory flexibility analysis is a result of a petition for writ of mandamus that ARSA filed back in 2007 regarding their drug and alcohol rules and their noncompliance with the RFA. Just recently, in response to the court's order to show cause why the writ should not issue, the FAA basically once again just stated that the rule will not have a significant impact on a significant number of small businesses, and therefore we certify that an analysis will not be required. So I think that's no change in the behavior of agencies, in our opinion.
From the food manufacturing standpoint, we're gearing up for the new FDA regulations that affect businesses like ours. So no real surprise that it's coming. Just want to make sure we have everything ready. So that's anticipated additional regulation. Not that it's bad regulation, but we're just making sure we're prepared.
We've got a little bit of a time crunch, so I'm going to turn to Ranking Member Velasquez for questions.
Thank you. Mr. Fabian, you suggest that agencies should account for the indirect costs of regulations. And I believe that your experience with the FFA makes it a clear case for this. However, implementing this change is a different matter. How should indirect costs or indirect be defined, and how far should agencies be required to go in determining the indirect cost of the regulation?
Thank you, Ranking Member Velasquez. In my opinion, it should be the population of small businesses that will be affected by the rule. In our case, it was the FAA stated that, well, the drug and alcohol rules apply to air carriers, so therefore we only have to consider the direct cost of that group of businesses, not at any tier down the line. That's more indirect, and I think there's no bright line for determining where the line would be drawn for the indirect costs. However, anyone that would have to be compliant with the rule, I think, should be considered.
Sure. Mr. Frula, in discussion concerning RFA, some observers have suggested that the SBA's Office of Advocacy be given an expanded role. For instance, you recommend that advocacy be given the authority to write rules implementing RFA. Others have suggested that advocacy be given explicit Chevron deference. What would be the result if advocacy is given new rulemaking authority for RFA and such Chevron deference?
What I think could happen that would be constructive, because the SBA produces guidance anyways on RFA compliance, is the creation of a standardized set of guidelines about how Reg Flex analyses should be conducted, because if there is an expert in how to do an RFA analysis, it's that agency, and that's where the deference would come from. I gave one example in my testimony where we had a case for the National Federation of Independent Business where EPA had based economic impacts analysis on changes to revenues without looking at profit. And it's pretty clear that you pay for changes out of your profit, not out of your revenue. And the Federal District Court here in D.C. Deferred to that decision by EPA, even over SBA's objection. I mean, that's a clear example, I think, where centralized. And
if you were to prioritize, what do you think is more important, giving advocacy the right to, the authority to write rules, or giving them Chevron deference?
I think they go together, because by writing the rules and being tasked as the expert to write the rules, the deference should follow.
But if I ask you which one, if prioritize one or the other, which one would come first?
I think they're of a piece. I think the reg writing authority would get you to the deference, but the deference would be the place to look, at least in terms of the reg writing. I mean, there's other issues relating to alternatives, which I've raised. It's trickier.
Among the witnesses today, there have been many proposals about reforming the RFA. And this includes expanding the panel process to all federal agencies, giving SBA's Office of Advocacy rulemaking authority, strengthening outreach to small businesses, and making the analysis required by RFA more specific. So if we count the different proposals, close to 10, outlined by the different witnesses, would advocacy's proposed fiscal budget 2012 staff level of $1 million will be enough to implement all these proposals?
I mean, what I've said in my testimony is, I mean, there may be reason to be judicious about expending the panel process. I mean, you are looking at major rules, not every rule. And I think the SBA, they need more budget to do this. If Congress is going to say small businesses are the engine of job creation and growth, and we have this agency,
you know, we are in the midst of PR negotiations. Yeah. And so people are asking to cut the budget, not to increase the budget of any agencies. If you have to guess how many more employees and how much more funding would advocacy need, do you have an estimate?
I think I'd have to defer to them on that. It would probably depend upon the. You could write the regs with probably the workforce you have. I mean, a lot of that information is already contained in their guides. In terms
Remember
of
now that the Dodd-Frank reform, regulatory reform, now it will cover all the agencies, and SBA Office of Advocacy will have to be part of that. Mr. Draper, you mentioned that you are worried about duplicative regulation, particularly regarding food safety inspection, which you are already subject to by the state of Florida. Mm-hmm. Can you discuss how these inspections impact your business and your annual costs?
Our regular inspector, as I mentioned, is the Florida Department of Agriculture through the USDA. Additional inspections require significant time, mainly my time. We're not of a size. I do have a full-time quality control director, but when we have inspectors come in, there's times when they're not really familiar with dairy, but they'll command our time, and rightfully so. But we feel that our existing inspectors are doing almost everything the FDA does. They're just the FDA tends to focus more on labeling, paperwork, things like that, record keeping, whereas the FDA is more, the Florida Department of Agriculture is more involved with our actual processes and pasteurization, things like that. So it struck us as that may be something that could be more efficient. The FDA certainly has a role, but our experience has been the dairy part of their inspection is not at the level that the Florida Department of Agriculture is.
And Mr. Squire, do you have a recommendation as to how can we close the loophole that would allow for agencies to certify that they have conducted the required impact analysis?
Yes, I believe my recommendation, Ranking Member Velasquez, would be to just clarify the RFA to make sure that the agencies have the directive from Congress to properly offer alternatives for small business. Again, I fall back on our recent experience with the FCC. One of the things that small companies, small rural telecom providers such as mine is criticized by the FCC for is our corporate operations expense. The size of those expenses is in comparison to our overall operating expenses. But we only have those expenses because of the degree of regulation that's impressed on us by the FCC. So it's a real tough situation for us. So I believe that this body can clarify for federal agencies that they need to come up with the alternatives.
Thank you. Thank you, Mr. Chairman. Mr. West.
Thank you, Mr. Chairman, Madam Ranking Member. In a previous career, I had a pretty simple life. When you're sitting on an airplane and you got a parachute on, the light's red, you don't jump. When the light's green, you do jump. So when I'm sitting here and listening to is that we saw that there was a problem with burdensome regulation back in the 70s. We created an agency, or this act, the Regulatory Flexibility Act. And now we come along, we have federal agencies that are not adhering to the analysis or the findings or what have you of this RFA. So my question is, in the simple world, what do you think is driving the federal agencies not to adhere to the RFA? I mean, is it belligerence? Is it the fact that they think they're untouchable? I mean, what are the things you believe is causing this this rub, this recalcitrance?
I can start. I'll just mention from our world, again, the food processing world, kind of what I mentioned to Ranking Member Velasquez, that the certain agencies have a focus, what they've done well, and then they might also pick up other industries as part of it. Dairy, our world is a specific, and we have specific inspectors now that are, in a lot of cases, former dairy people with good knowledge. They come in, they share the knowledge, which is appreciated. Sometimes when we have other agencies that come in, not just the FDA, but anyone else that might come in to inspect, maybe they have to, they've been wrapped up because we're food. Maybe it should be more industry specific, and the people that do inspect those businesses would have the industry experience.
Open to the full panel.
Congressman, I think that as I stated in my oral and also in my written testimony, is the fact that it's easy for agencies to circumvent the RFA and just certify that it's inapplicable and really without repercussion. I think it's, at least our case proves that the RFA does not today have real teeth, and that if the RFA is viewed as a burden and something to avoid, it can be accomplished rather easily.
I'd agree with that. We had some early cases, for instance, where a federal court in Florida had designated a special master to look at the agency's good faith, in complying with the RFA. I mean, that kind of thing, if you can get to that point, can get you some attention. But that's not an everyday occurrence in litigation. I think there's two ways this happens. One is agencies just don't get it. They really don't get and understand the impacts that their regulations have on small businesses, and so they just proceed. Others have their mission and they don't care. They want to proceed. So you have those two are the two animating factors I think we most often see.
I don't believe, Mr. West, that it's belligerence. At least I hope that it's not in the cases that we've had. But I do believe that it's complete indifference, because the courts have said that the act itself is procedural only. And so why would an agency devote a lot of resources and time to an RFA analysis? I believe congressional mandate to put some teeth into the act would go a long way.
And one final question, if I can. If you look at the time period when you first started your business, and if you were to try to go into that endeavor today, do you think that it has become easier, or do you think there are more obstacles out there for you to try to create the exact same business that you did, 20 or however many years ago?
Clearly for us, Mr. West, it would be almost impossible to start our business today. We began in 1954 as a rural telephone cooperative with a handful of farmers and ranchers throwing $50 into the kitty to string wires on the poles, largely unregulated. And today we have a full finance department, kind of a mini accounting firm in our own small company. We have lawyers and economists, much more complicated industry now, probably impossible to start.
I think I'll demur. But I will note there are a lot more lawyers now than there were in 1987 when I started.
I mentioned we probably look at opening up a store, but taking the leap into the manufacturing. Now there's so many new things. Over the past 30 years when we started, allergens weren't really on the radar screen that much. Now it's a huge part of our industry and our whole production process, and the regulations that we're following now. It'd be a daunting task, but in our case, starting small, we took one step at a time, and we'll keep doing that. But there are more challenges now, but we hope to, as evidenced by our membership International Dairy Foods, and just trying to be fully educated, having a quality control director that we can meet all the current regulations, but it is a task.
Thank you, Mr. Chairman. I yield back.
No questions? I want to thank the witnesses for being here. I apologize. We're going to have to end just a little early. We have a briefing on Libya that we definitely want to be at. But again, I appreciate your testimony and for coming in. I apologize for the votes, but the committee is going to be examining legislation when it comes to the RFA, so that businesses, obviously can create jobs and don't have to continue to comply with some of the ridiculous regs that are coming out that have not taken into account how much it's going to harm business and how much effect it's going to have on job creation. But with that, again, I appreciate you being here, and we'll say the hearing's closed. Thanks.
Thank you.